Thank you. Good afternoon, Mr. Manoim. Good afternoon, sir.
Afternoon, Chief Justice. Can you hear me?
Yes, I can. Are you well?
Very well, thanks, Chief Justice.
You seem to be relaxed and comfortable, so I won't waste time on you.
Thank you.
You were with the competition tribunal for about 20 years, am I mistaken?
That's correct, 20 years. 10 years as a full-time member and last 10 years as the chairperson.
I will leave most of what needs to be asked at this preliminary stage to the JP. I just want to know one thing. There seems to be a considerable delay in having both the Competition Commission, the Competition Tribunal, and the Competition Appeal Court help achieve what the Competition Act was enacted to help us achieve. Is that the sense you have, or could it be that I'm not as informed as I ought to be?
Chief Justice, I think we have actually achieved what we're out there to achieve. It's not a finished project, but not all problems in the economy are problems created by competition problems, and not all competition regulation is a responsibility of the competition authorities. But to the extent that we had things to do, we've intervened in probably every sector, and I think that we have made a difference. But it's an ongoing project, it's a never finishing project.
And you're quite satisfied that the jurisprudence developed, particularly at a competition appeal court level, is such as to help open up the door to meaningful participation in the mainstream economy to the previously excluded, and that both the legislation and the way it is interpreted helps to strengthen the hand that ought to keep checks on collusions and this, I forgot the expression, this clapping together that tends to frustrate the objectives of competition appeal at the Competition Act.
Chief Justice, I think the experience is variable at the level of what you're saying of cartels or collusion. There have been a lot of decisions, and I think there is greater clarity than there was before. In other areas such as abuse of dominance, there is some jurisprudence, but it needs to be developed further. In merger control, I think there's quite a lot of experience and clarity. But the Act was recently amended 2 years ago to deal with issues of inclusion. And those sections still need to be litigated. And so there's, at this stage, a lack of clarity, a lack of jurisprudence. But those are terribly important sections which will properly litigate, give people access to the economy which they haven't had before, such as what it's like to experience the buyer power of an incumbent firm, or how to be included in an economy where there's a club of people trying to keep you out.
And you would say that the progress is commendable. We shouldn't get impatient with the pace at which things are happening, and the direction in which the development of the jurisprudence is going.
I think it's developing, but I suppose we can always be justified in saying it should be developing further and at a greater speed.
All right. Thank you very much. JP, before I hand over to you, let me first get a list of my colleagues, our colleagues who would want to put questions to Mr. Manoim. Colleagues? Okay, it doesn't look like there's any colleague who has a question. Over to you, JP.
Chief Justice. It's
Is that Commissioner Tsepe?
It's Chief Justice.
And both.
And Schlemmer, please.
And Lamola CJ, my mic was not properly functioning.
Okay, Minister. All right. JP?
Thank you very much, Chief Justice. Mr. Manoim, good afternoon.
Afternoon, JP.
I have circulated your spreadsheet of work allocations since you started acting in 2019. I see that the only work areas you haven't covered are the special trials, which are the trials of long duration, as well as the criminal trial court. But that's not your fault. It's the person who allocates work. He didn't put you there.
Thank you. Thank you.
That's correct.
That is correct, yes.
Yeah. But what the spreadsheet also reveals is that you've done quite some heavy lifting. You've got 5 weeks in the opposed motions court. Can you confirm that at any given point in time per week, how many opposed motions would you get if you're allocated there?
It's varied because I think during the lockdown we got fewer, but sometimes you can have 15 to 20. Sometimes they settle on the day, so it varies.
But that's where most reserve judgments come from, isn't it?
That's correct.
You've also dealt with 2 full court appeals. Did you write any of them?
I haven't written any full court appeals yet. I got one last week. We heard a full court appeal and I've been allocated to write it.
Right. And you had 2 special motions. That is the special motions that are allocated outside of the ordinary opposed motion.
I think that I've one settled. We were ready for trial and it settled. Yeah. The other I wrote a decision.
How did you find that one that you wrote?
It was a very interesting case, and it was nice to actually hear something over a longer period of time. It involved removal of trustees in a family trust.
Yeah. And my last question to you is, the 44 weeks you've acted in the division since 2019 is in addition to your extensive judicial exposure sitting in the competition tribunal, am I correct?
That's correct. The tribunal is an adjudicative body. We hear trials, we hear motions, we really do judges' work, although we're an administrative tribunal.
Thank you very much, Chief Justice.
Thank you, Judge President. Honorable MEC.
Thanks so much, Chief Justice. Good evening, Mr. Manoim.
Good evening.
What's your attitude towards judges that don't deliver judgments within the 3 months norm?
Well, judges must deliver on time. That's part of their job. If they don't meet the 3-month obligation, there needs to be a reason. There may well be a reason. But if there's not, then I think it should count against them.
Do you have any outstanding judgments?
At the moment, just the appeal I mentioned from last week, I've got is my one reserve judgment. But we heard the matter on Wednesday last week.
Thanks so much, Chief Justice.
Thank you, MEC. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Mr. Manoim. Chief Justice, may I declare right now that I was a candidate attorney under Mr. Manoim when he was at Chittle Thompson and Haston, a great mentor indeed. Thank you. Mr. Manoim, just on the issue relating to your criminal work, could you just, and I say this because I know that in your time at Chittle Thompson and Haston, you would have been involved in a great deal of work in criminal work, and I just wanted to talk us through that, including constitutional work that you would have done over and above the work that you would have done sitting as a member of the competition tribunal. Thank you.
Okay. When I was at in my firm of attorneys, Chittle Thompson Haston, the most of my time in practice was actually doing political trials, and they were criminal trials, and they were actually very lengthy trials where quite a few complex issues were raised. Now, admittedly, it was at a time before the Constitution, so certain of the principles that have evolved post the Constitution didn't arise, but nevertheless, it is a form of, I did get exposed to criminal trial experience. In the competition tribunal, we run cartel cases. Cartels have got a criminal element to them. Cartels are a criminal law offense as well, but where we run them, they're a conspiracy. So a lot of what you see in a criminal trial would come up in a cartel case.
And in relation to constitutional law matters?
In relation to constitutional law, my time in practice preceded for the most part, the adoption of the Constitution. The constitutional issues have arisen time and time again in the competition tribunal because there have been constitutional challenges which we've had to address. Some of them are in the judgments here as to whether we could, for instance, fine people because we are not a criminal system, as to whether we were sufficiently independent. And the economic rights came up. Then we have jurisdictional points which involve the common law and the Constitution. So it's come up on frequent occasions.
Thank you, Chief Justice. Thank you, Mr. Manoim.
Thank you very much, Commissioner Tsepe. Advocate Mpofu, JSC.
Thank you. Good afternoon, Mr. Manoim. How are you?
Fine, how are you?
Very well, thanks. I'd like you to just take the commission or the commissioners through. I said to an earlier candidate that that seat you're sitting on is for bragging and not for modesty here. So can you please just explain, when you say you have 20 years of adjudication experience in the competition tribunal in particular, to what extent is that relevant? Have you found that relevant to your stints as an acting judge, particularly because some of those cases include issues of procedure, jurisdiction, exceptions? I remember one of the biggest cases there was the Standard Bank, the banking manipulation of the currency case, where the biggest cases were jurisdiction, exception, very complex. And also that many of us and very senior advocates have appeared there against each other. Some of the most eminent counsel do battle in those forums. So it's not just some little forum somewhere in a corner. Can you just explain that intersection and how that would assist you if you are appointed?
Well, the experience of being in the competition tribunals might seem narrow because you're looking at one area of substantive law. But we actually, when we hear a case, we're crossing into all sorts of areas of law, company law, sometimes trust law, intellectual property. We're also dealing with civil procedure issues. There are exceptions you have to deal with. We run trials as we would a civil trial where lawyers appear and they object and you've got to make decisions on the spot. As you mentioned the banks case. That was a case where there were 13 legal teams in which all of them were led by a senior counsel. So one of the challenges is actually how do you manage a trial like that? And I think one of the things that I've learned is how do you handle a complex case to make sure it's run on time and run efficiently against quite a few big people in the room. You led one. You were one of the eminent counsel who led one of the teams. I think it was 12 teams up against you. And we had to make sure that you got your voice in the room and not just all of them all the time. So I think many of the challenges that you're going to get in a courtroom, this helped as preparation. And then you've got to write decisions, often very, very complex decisions, and write them in a way that's comprehensible to people to see what's going on.
Thank you. CJ, out of interest, in that case, there were maybe about 100 lawyers against us when I counted in the room.
I think the room wasn't big enough to fit them all in.
The room was not big enough, even for the egos. Thank you. So the second question is around your student activism. We just had somebody here who wasn't sure how exactly he was a student activist. So you were involved in student politics when it was really, really unfashionable as a member of NUSAS and an activist, part of the SRC and so on. Can you, and the question that was put by the CJ to the previous candidate was, what is it that drove you to participate in the struggle at that level? And whatever it is that drove you to do that, how is that going to inform your work if you are appointed? In other words, in the area of human rights and abhorrence of inequality.
When I was a student, I was the president of the SRC at the University of Witwatersrand, and I was the vice president of what was then the National Union of South African Students, or NUSAS. What got me into it, I suppose, was an early political consciousness, which had been formed partly by my family, partly by environment of people I was with. So I didn't see involvement in student politics to get the cheapest chips prices in the canteen. I saw a greater involvement, and we tried to both conscientize what was largely then a white student body about the issues of the country, with sometimes mixed success. But we also had contact with student organizations at the time. It was AZASA and it was COSAS, and we tried to get involved in certain of their activities with them. That had to be in some way clandestine, because those people had to operate underground. They met with us openly, there would be problems. And also we couldn't use the resources of the, as it were, the so-called white SRC to assist other organizations. But we found ways to do it.
Thank you, Chief Justice.
Can I just make a follow-up, Chief Justice?
Thank you. I couldn't make out the voice. Is that you, Minister?
Muimang, Chief Justice.
Oh, okay. Well, maybe I'm prophesying.
Prophetic.
Honorable Muimang.
Thank you, Chief Justice. I guess you are familiar with Justice Alvie Sachs.
Sorry, am I familiar with him?
Yes.
Yes.
There are two questions that he poses in one of his books. The first question is that if a paternity test were done on South Africa's widely admired constitution, whose DNA would come up? Is the constitution just a beautiful piece of paper or not? What is your view on that?
Sorry, sorry, I couldn't hear what you said. Which view would come up? I think I lost part of it.
Okay, let me relax.
Thanks. Perhaps a little closer. Thank you.
He poses two questions in his book, in Dedication to Oliver Tambo's Dream. He poses two questions. The first one is, if a paternity test were done on South Africa's widely admired constitution, whose DNA would come up? The second one, is the constitution just a beautiful piece of paper or not? What is your view with regard to these questions?
Well, I think we've got to make sure that it isn't just a beautiful piece of paper, that it's implemented, and that it has beautiful language in it. But unless judges are continually trying to implement it, and I see it as a working project, then it will simply be a beautiful piece of paper. We've, as it were, got to get the beauty to work, and that's our job as judges.
Thank you, Chief Justice. Thank you, Justice Ma'am.
Thank you, Honorable Muimang. Professor?
Thank you, Chief Justice. Good afternoon, sir.
Yes,
I should perhaps also just declare that we met when you worked at WITS. We didn't get to know each other quite well, but we did work together. Most of my questions have been covered, but I have just one question for you, and that relates to the time that it took for the judgments in the competition tribunal to be written. I've noticed in some of them it took around about a year for a judgment to come out, whereas with your judgments at the Gauteng court, they come out very quickly. Is it due to the complexity? Could you perhaps just elaborate a little bit on that?
You're correct. There are one or two which have taken a long time to do. I think there are a couple of reasons for it. One is the complexity, and sometimes when we've written a judgment, because we've got to deal with economic issues, we've in fact asked people to give us more information whilst you're writing the thing, because you want the information isn't satisfactory. Secondly, as chair, I was also managing the organization, so it meant that it cut down on my ability to write. The third thing is that there's no recess in the competition tribunal; it sits all the time, and you've got the benefit of a recess in the court. So you're actually continually having to have new matters. We also don't have acting members. So there's no ability in the competition tribunal to not hear a case. You've got to give priority to hearing cases. And so judgment writing falls behind. There have been some reforms which I've suggested and the minister then have taken up to try and deal with that problem, but they're institutional problems.
Thank you, sir. That answers the question. Thanks, Chief Justice.
Thank you, Prof. Honorable Minister.
Thank you, CJ. I must also declare that I drank lots of water with Mr. Manoim in various conferences of the competitions.
It was only water.
Well, Honorable Minister, I think they are wondering whether it's waters of immortality or
yeah, no, thank you. Mr. Mayor, my question relates to where you started with the CJ. What other instruments do you think could help us to deconcentrate the economy from the monopolies? Because you answered that it's not only the Competition Act that can help us in that.
Well, I think there are various ways. One of the new powers under the Competition Act is the market inquiry. And the market inquiry main focus is on economic inclusion. And so once you can get inclusion right, you erode monopolies because they get competed down. Most monopolies are actually inefficient. And so if they face some competition, we will erode them. That's probably the quickest and best way to get rid of monopolies. The other problem that we've experienced, and it's outside of the competition authorities, is that for many industries, you need a license to actually enter the industry. And without a license, you can't compete. So historically, for instance, we've been a bit critical of the banking regulator because it's taken many years for them to issue new licenses. Similarly for the telecoms regulator. And if you issue more licenses in a regulated industry, you'll get deconcentration and more entry. Also with new technology, it's more likely that you'll get entry than you did in the old bricks and mortar economy.
One of the things I had observed, you may not want to say whether you agree with me or not, but you can make an observation, was that sometimes the tribunal felt frustrated by some of the judgments at the Competitions Appeals Court, in particular that it seems to have allowed parties to raise characterization as a defense against the cartel conduct.
There have been issues on which we and our colleagues in the appeal court would not have agreed on interpretation. So the characterization is an issue in a cartel case as to whether you needed to say with people fix the prices, you've first got to characterize whether they're in fact doing that or not. In other words, we've always felt it was an unnecessary step. But I think one can deal with that. There was a suggestion there should be characterization should actually find its place in the new act when amendments were put in. And there was opposition to that, fortunately, by the Commission, and it didn't go in. But sometimes, in a sense, we have differed with them, but I respectfully say that on these issues, there can be differences. They're very, very difficult issues.
With your indulgence, CJ, last one.
Yes, Honorable Minister, please go ahead.
Yeah, what could you say has been your contribution in laying the foundation for the current amendment to the Competitions Act, and how do you think they can change the structure of the economy?
Well, I think in some way we've written certain decisions where there have been, due to later competition appeal courts, some difficulties in interpretation, and the amendments have been done to try and deal with those situations. I can think of two on the substantive area, predatory pricing and what's called excessive pricing. There have also been we've made certain suggestions in relation to merger control that will expand the jurisdiction of consideration of mergers. And thirdly, the issue of a market inquiry is a very, very powerful tool for the competition authorities and should be a quick one to use. And that's gone into the act, and hopefully we will see the results.
Thank you, CJ. Thank you, Judge.
Thank you, Minister. Just my last question, Mr. Manoim. You know, there are two competition matters before the Constitutional Court at the moment. I must say I have found a lot of depth and breadth in their reasoning. And some of the decisions tend to be long, up to over 400 paragraphs. Is there a way in which, that's the first question, is there a way in which the decisions could be shortened without compromising the quality? And number two, given the critical role that the tribunal plays, if you were to equate it to any of our existing courts, so that its role is properly appreciated, where would you place it?
On your last point, I suppose the equivalent of the competition tribunal would be the labor court, where you've got a specialist court, which is a court of first instance. So I think that would be the closest equivalent in the legal system. On why these judgments are so long, I would have to plead guilty myself. The two that are before you at the moment are not my decisions. I was on the panel, the one, but I didn't write it, and the other one was decided after my time. I think it's because we not only have to deal with legal issues, we often got to deal with economic issues. And so as a result of doing an economic analysis, the judgments may take longer than one would like them to take. But because you've got to deal with a number of arguments, we can't dispense with them. Otherwise, people will say, well, you left out this particular issue. I think that over time we may refine them, but you will find that competition judgments of courts of first instance are generally quite long if you were to look around the world for what they are. Once you go on appeal, their points narrow, and so there should be less that has to be decided.
Well, I was hoping you were on a lighter note. I was hoping you were going to come up with something that could ward off the attacks against the Constitutional Court regarding the length of our decisions.
We did that on this side of the table.
We did. Madonsela and I were saying that is very thick coming from the Constitutional Court about the length of judgments.
Thank you very much, Mr. Manoim. You are excused, sir.
Thank you very much, everybody. Thank you.